Namaste. So I am Akshay Yadav, Teaching Associate, National Law School of India University, Bangalore. Even I have also completed 40 hours of mediation training program. I am very much thankful for Professor Ashok R. Patil for providing me an opportunity to deliver a sessions for this course that is on conflict management through mediation. So in this session, we will be discussing on legal development of alternative dispute resolution in India. So this is the last topic of week 1. In this week, we have already discussed the course outline. Even we have also discussed the need of alternative dispute resolution and the nature of disputes, conflict, and conflict management. So basically, in these previous sessions, we have discussed how justice is being delivered and what are the legal lacunas or difficulties in delivering justice to the people by means of the courts which are established, wherein we have Supreme Court of India at the top level, High Court at the state level, and district and taluk level courts. Even we have tribunals which are established under special legislations like consumer. Under Consumer Protection Act, we have National Consumer Commission, District Consumer Commission, State Consumer Commissions. For company, under the Companies Act, we have National Company Law Tribunal and various other tribunals we have established. But because of various factors that all are discussed in the previous sessions, because of all those factors, we have failed to deliver justice at its spirit. So that is where we feel that there is a need of alternative dispute resolution mechanisms to deliver justice in a speedier manner. So the alternative dispute resolution mechanism, when we trace out its evolution, we can trace out long back from the period of Vedic as well. But for the understanding, for easy understanding, we will just discuss with respect to the legal developments of alternative dispute resolution in India. So prior to the Indian independence, as we all know that we are governed by the British rule, wherein during the British rule itself, for the first time, arbitration was elected as a mode of dispute resolution, or it was recognized in India in the year of 1879 itself, and also found a place in the Civil Procedure Code 1908, the one which still we follow that. So Arbitration Act was enacted, a special Arbitration Act was enacted in the year of 1940. The provision for arbitration was also originally included in the Civil Procedure Code of 1908, and that was been repealed from the Civil Procedure Code by the enactment of this Arbitration Act of 1940. And that was the condition wherein the court was unaware as to how the mode or how to provide a pending case before the court to the arbitration mechanism, on what basis the jurisdiction is to be required to be considered. So those all things were missing. Even after that, after the year of 1940, so the Arbitration Act, after repealing the arbitration clause which was earlier there in the section 89 of the Civil Procedure Code, after repealing that, even the Arbitration Act took it forward and were used to resolve the dispute through arbitration. But after the post-Indian independence, India enacted the Constitution of India, which can be held as the base for the rule in India, wherein the Constitution of India has granted various fundamental rights to its citizens, and through Article 21 of the Indian Constitution, it also granted a right to have access to justice, and the access to justice should be in a speedier manner, in an affordable manner, which is granted through the fundamental right. And the directive principle of state policy enshrined under Article 39 Clause A of the Indian Constitution mandates the duty obliged on the state to promote a laudable objective of promoting legal aid to the needy litigants and obliges the states to make access to justice at an affordable price. Even the same has been reiterated by the Supreme Court in various cases. One case which is very famous and which has laid down the principles of access to justice in case of Anita Kushwaha versus Pushpa Sudan. So this is the case of 2016 Supreme Court at page number 509, wherein the constitutional bench of Supreme Court held that access to justice is a fundamental right and laid down four main facets of the essence of access to justice. That is, effective adjudicatory mechanism, that the state should provide an effective adjudicatory mechanism. The mechanism so provided must be reasonable, accessible in terms of distance. The process of adjudication must be speedy, and the litigants' access to the adjudicatory process must be affordable. So it includes the Supreme Court lays down the four facets, that is adjudicatory, it should be an effective one, reasonably accessible in terms of distance, it must be speedy, and even affordable. So with these principles, four principles which has been enunciated by the Supreme Court were well recognized even before the year of 2016 as well. And those principles can be witnessed in various legislations which has provided opportunity for all the citizens to have or to get a speedy justice by means of various alternative dispute resolution mechanisms which are established in India. So post-independence, we have various legislations which recognized the alternative dispute resolution mechanism. One such example is Industrial Dispute Act of 1947, wherein the conciliator appointed under Section 4 is charged with the duty of mediating in and promoting the settlement of industrial disputes. If there are any disputes relating to industries or industrial employments or industrial disputes, so such disputes can be settled by means of conciliator, who will be charged with the duty of mediating and promoting the settlement of such disputes. Along with this act, there is another legislations which we can say that one of the benevolent legislation or a social benevolent legislation for all the citizens of India, that is Legal Service Authorities Act of 1987. So under this act, there are various authorities which are established at the national level. We call it as National Legal Service Authority. Even this authority are also established at the state level, that is State Legal Service Authority and District Legal Service Authority as well. Even at the taluk level, wherein under this act they have established the councils. So the National Legal Service Authority is acting as a central authority, wherein the Chief Justice of India as its patron in chief. And this authority is vested with the duties to perform the functions to encourage the settlement of disputes by way of negotiation, arbitration, and conciliation. Even under this Act of Legal Service Authorities Act of 1987, even it has enhanced the legal education and provide the legal aid to the needy people who are not affordable to have justice, to get justice. So the government of India is providing the funds to the needy people to have access to justice, and the procedure by which the people who will get the legal aid. So those all things are derived under this Legal Service Authorities Act of 1987 to make justice at an affordable price. And with an intent, under the Legal Service Authorities Act, as we all know, both parties are required to be heard, and it is the principles of natural justice, wherein in case if a party is not able to get an advocate hired for presenting his case So under that circumstances, the legal aid committee which is established at that court may also assign an advocate on its behalf, on the party's behalf, to represent the party before the court, and it's free of cost. Even that mechanism is also statutorily recognized under the Legal Service Authorities Act of 1987. Even under this act, there is another mechanism which has been established to render a speedy disposal of disputes, that is establishment of Lok Adalats. So Lok Adalat is nothing but it is a people's court. We have elaborated the difference between the Lok Adalats and mediations in the second week of this course, and has been discussed in depth over there. So the era of ADR in India can be discussed. We can say that the Arbitration and Conciliation Act in the year of 1996 is the one of the most important stage to recognize the alternative dispute resolution mechanism in India. So by enactment, so there was Arbitration Act of 1940 which was governing the arbitration procedure in India, and that was been revamped in the year of 1996 by means of Arbitration and Conciliation Act of 1996, repealing the Act of 1940. So this act aims at consolidating the law relating to domestic arbitration, international commercial arbitration, enforcement of foreign arbitral awards, and rules regarding conciliation as well. So this act was enacted based on the ancestral model of the arbitration and conciliation rules, which are globally recognized, and based on that, this act was enacted, which aims at consolidating the law relating to domestic arbitration and also international commercial arbitration as well. And through this act, so there was a boom around the country with respect to the alternative dispute redressal mechanisms that can be adopted for resolution of dispute, which can be held as a speedier manner for resolution of disputes. As we have already discussed with respect to the Civil Procedure Code 1908, which recognized for the first time in the year of 1908 itself through section 89, which included the arbitration clause, but it was later repealed by the Arbitration Act of 1940. The same section was again refurnished or re-amended in the year of 1999, wherein section 89 of the Civil Procedure Code 1908 and even Order 10 Rule 1A, 1B and 1C was included under this Civil Procedure Code of 1908, which gained the alternative dispute resolution, the importance of alternative dispute resolution in India. So I am pained to observe that the judicial system in the country is almost on the verge of collapse. These are the strong words I am using, but it is with the considerable anguish that I say so. Our judicial system is creaking under the weight of arrears. As we have already seen that there is a wide numbers of pending cases. Huge pending cases are been pending before the Supreme Court, before the High Court, and even before the district courts because of various delayed procedures. Former Chief Justice Honorable Shri P.N. Bhagwati says that, see, our judicial system is creaking under the weight of arrears because of this delay in proceedings, and that is where the judicial system is saying that the judicial system is creaking under the weight of arrears. So with this statement, so there was a boom around the country, and by this statement, this is where the CPC was been amended and included section 89, which confers the jurisdiction on the court to refer a dispute to an ADR process, whereas Rule 1A to 1C of Order 10 laid down the manner in which the jurisdiction is to be exercised by the court. The section 89 reads as the settlement of dispute outside the court, where it appears to the court that there exists an element which may be acceptable to the parties, the court shall formulate the terms of settlement and give them to the parties for their observation, and after receiving the observation of the parties, the court may reformulate the terms of possible settlement and refer the same for arbitration, conciliation. Judicial settlement includes settlement through Lok Adalat or mediation. So here I am stressing the word may. So the may, I am stressing the word may, that the court may reformulate the terms of possible settlement and refer the same for arbitration, conciliation, judicial settlement, mediation. So as we all know that, or the very feature of the alternative dispute resolution mechanisms is a voluntariness, because the parties may choose. That is why the word may is being used, and the court may reformulate the terms of possible settlement and refer the same for mediation or arbitration or conciliation. So that is where, and even the term shall is been formulated. The court shall formulate the terms of settlement and give the parties for their observation. So that means, so it can formulate the terms of settlement, that whether it can be settled through arbitration, whether it can be settled through conciliation, and then it and give the parties for their observation. After receiving the observation of the parties, then the court may refer it to the following alternative dispute resolution mechanism recognized under this section. So the same has been discussed in the case of Salem Association, so that we will discuss in the future slides. The subsection 2 of section 89 of Civil Procedure Code reads as, where a dispute has been referred for arbitration or conciliation, the provisions of the Arbitration and Conciliation Act of 1996 shall apply as if the proceeding for arbitration or conciliation were referred for the settlement under the provision of that act. So if any case which is pending before the court, if it is referred to arbitration or conciliation, the procedure, the settlement procedures will be governed according to the Arbitration and Conciliation Act of 1996. The subclause B of this subsection talks about Lok Adalat, which reads as, the Lok Adalat, the court shall refer the same to the Lok Adalat in accordance with the provision of subsection 1 of section 20 of the Legal Service Authorities Act 1987, and all other provision of that act shall apply in respect of the dispute so referred to the Lok Adalat. So Lok Adalat means by People's Court, which is established under the Legal Service Authorities Act of 1987. And what all are the matters that can be settled through mediation is also discussed under the Act of Legal Service Authorities Act of 1987, which can be settled through Lok Adalat. So those all things are being discussed in depth in the second session, in the second week of this course. But here I'm just reading out that this is the base for which the Lok Adalat is one of the alternative dispute resolution mechanism recognized under the Civil Procedure Code. For judicial settlement, the clause C of the section 89 of subsection 2 of section 89, the court shall refer the same to a suitable institution or a person, and such institution or person shall be deemed to be a Lok Adalat, and all the provisions of Legal Service Authorities Act of 1987 shall apply as if the disputes were referred to Lok Adalat under the provisions of the Act. And for mediation, the court shall effect a compromise between the parties and shall follow such procedure as may be prescribed. When we look after these two definitions, we can find out that there is an error in this definition which has been provided under section 89, and it is not yet been amended, but we can feel that there is an error in the definition. That so it is what happened here is the definition which has been given for mediation is for the definition of judicial settlement. So that is also cleared in case of Afcons case. That is, the judicial settlement means the court shall effect a compromise between the parties and shall follow such procedure as may be prescribed. So this is called as judicial settlement, whereas the mediation is a different thing, the definition which is not been provided under the section 89. So judicial settlement means a compromise entered by the parties with the assistance of the court adjudicating the matter and another judge to whom the court had referred the dispute. And even the judicial settlement is defined as the settlement of a civil case with the help of a judge who is not assigned to adjudicate the dispute. So these are the two definitions which clears out. So these are the bare provisions or the dictionary meaning of the judicial settlement. This is where it clears that the judicial settlement means a compromise entered by the parties with the assistance of the court. So that we call it as judicial settlement, whereas the definition which has been provided under section 89 has certain errors, and this is where it clarifies. And further, the Supreme Court has also clarified, as I stated earlier as well, in the case of Afcons case. The another provision of Civil Procedure Code, that is Order 10 Rule 1A, 1B and 1C of CPC, which was included by means of CPC amendment in the year of 1999. So the Rule 1A of Order 10 direct of the court to opt for any mode of alternative dispute resolution. After recording the admission and denials, the court shall direct the parties to the suit to opt either mode of settlement outside the court as specified in subsection 1 of section 89. So one of the option of the parties, the court shall fix the date of appearance before forum or authority as may be opted by the parties. So here, under Rule 1A, the direction of the court to opt for any one method. So it is up to the parties to decide whether they want to go to the arbitration or conciliation or lok adalat or mediation to settle out their dispute. And at what stage the court may direct? The court may direct only after the admission of the dispute suit before the courts. So once the court has admitted the case, then and then only it can refer to any one option that is available under section 89 clause 1. And it can also, the court can also fix the date of appearance. So on which date the party should appear before the alternative dispute resolution, that is arbitration or conciliator or mediator, or before the lok adalat. Even the court may ask the parties to opt any date on which date it is feasible for the parties to appear before these arbitrator or conciliator or mediator or lok adalat. So this is how the Rule 1A provides the flexibility to the court and even to the parties to decide the mode of dispute resolution and the time on which they want to appear before the concerned person. The Rule 1B of this clause, of this order, speaks about appearance before the conciliator forum or authority. Where a suit is referred under Rule 1A, the party shall appear before such forum or authority for conciliation of the suit. So even the appearance before the conciliator, so there is no requirement of any other mechanism. So once the court has been referred the case to the conciliator or mediator or arbitrator, the party shall appear before such authority for conciliation of the suit or dispute. Rule 1C, appearance of before the court consequent to the failure of the effort of conciliation. Rule 1A says about reference of dispute to the mode of mechanism. Rule 1B suggests about the appearance of the parties before the respective alternative dispute resolution mechanism, whereas Rule 1 clause C states about on failure of the alternative dispute resolution, what is the procedure that should be adopted. Once, because once the court has referred the case on failure of such alternative dispute resolution mechanism, the parties will again come back to the court, and whatever the matter which was pending before the court, it will be again taken forth. So appearance before the court consequent to the failure of effort of conciliation, where a suit is referred under Rule 1A and the presiding officer of the conciliation forum or authority is satisfied that it would not be proper in the interest of justice to proceed with the matter further, then it shall refer the matter again to the court and direct the parties to appear before the court on the date fixed by it. So, in this case, whenever there is a failure of the alternative dispute resolution mechanism, the arbitrator, the mediator, the Lok Adalat or the conciliator on failure direct the parties to again go back to the court, and it will again fix the date on which the parties are required to appear before the court, and the similar manner, the way, the procedure which is adopted at the court, accordingly the adjudication procedure will take place and resolve the matter before the court. So there was an issue. I was stressing the earlier 2 points, that is may and shall. So the use of word may in section 89, when it stipulates that the court may reformulate the terms of possible settlement and refer the same for arbitration, conciliation, mediation. This is how the word is been spelled in section 89, or the provision reads in the similar manner. So there was a thing like the court may reformulate, because it's being a voluntary process, a party-centric process, how the court may reformulate the terms of possible settlement. So that is not possible. Even the use of word shall in order 10 Rule 1A, when it states that the court shall direct the parties to the suit to opt either mode of settlements outside the court. Even this word shall, as we all see that it's a voluntary process, the court cannot mandatorily impose the parties or direct the parties to opt either mode of settlement of dispute. It cannot mandate. It has to be may. So the same has been discussed in case of Salem Advocates Bar Association Tamil Nadu versus Union of India. This is a case of AIR 2003 Supreme Court 189. The constitutional validity of this amendment made to the Code of Civil Procedure Code 1999 and 2002 was challenged, and the committee was constituted so as to ensure that the amendments made to CPC become effective and result in quicker dispensation of justice. The court opined that crisis which requires to be ironed out when can be identified and apprehension which may exist in the minds of litigating public or the lawyers clarified. So a committee was constituted under the Salem Advocates Bar Association Tamil Nadu case by the Supreme Court. The committee was headed by Justice M. Jagannath Rao and other members of the committee were Kapil Sibal, the senior advocate, Arun Jaitley, C.S. Vaidyanathan, D.V. Subbarao. The committee was asked to consider the said difficulties and make necessary suggestions in its report within a period of 4 months. The committee submitted its report and the same was considered in case of Salem Advocates Bar Association Tamil Nadu versus Union of India in the year of 2005. The court analyzed the report and issued guidelines for effective implementation of provision of section 89 and order 10 Rule 1A, 1B and 1C. Here, as per the recommendations of the committee, the court upheld the recommendation which made in the report of this committee and held that and it directed the high courts to frame a mediation rules, to establish the mediation centers in each and every states, and list the trained of mediators is prepared, and mandated the courts to refer the disputes to the mediation as well. So in this scenario, on the basis of the recommendation and the direction which was been made by the Supreme Court, all the high courts framed the mediation rules, they established the mediation center, they list out the mediators, prepared, and referring certain civil disputes to the mediation is mandatory. So these all things came light the mediation as an effective tool for resolution of disputes, along with the other alternative dispute resolution mechanism, that is arbitration, conciliation, and lok adalat. And this was the first case wherein it decided and various errors were being discarded in case of Afcons Infrastructure Limited and others versus Cherian Warke Construction Company Limited and others. So the facts of the case are the Cochin Port Trust tasked the petitioners with the development of some overpasses by way of a contract. The petitioner subcontracted some work to the respondents. The contract between the petitioner and the respondent did not have any arrangement for seeking resolution of disputes by arbitration. A case was filed for the reversation of around 2 crore rupees and interest. Eventually, an application was filed citing under Section 89 of the CPC before the trial court, praying for planning of settlement terms and reference to arbitration. The appellant filed a counterclaim objecting the reference to any form of alternative dispute resolution under Section 89. Ultimately, the matter came up before the Supreme Court. The Supreme Court referred this matter. There are various issues before the Supreme Court as to what is the course of action to be taken by the court in enforcement of Section 89 and Order 10 Rule 1A of the CPC, whether the consent of both the sides to the suit is mandatory for reference to the arbitration under Section 89. Even it also discussed what types of cases that can be referred to mediation. What is the role of a judge while referring the matters to the alternative dispute resolutions under Section 89. So these all things are being discussed under this case. The Supreme Court elaborated upon how the court is to deliberate on the nature of dispute, notify the parties about the ADR mechanism, observe the inclination of the parties, and then refer them to the mechanism of their choice accordingly. So whenever a matter that is been before the court, and if there is a concern that, or if the court deems that the matter can be settled through mediation or arbitration or conciliation or lok adalat, under that circumstances, only on that basis the court should not refer such matter to the ADR mechanism. It should also deliberate the nature of dispute, notify the parties about the advantages and disadvantages of the alternative dispute resolution mechanism, the inclination of the parties. It should observe the inclination of the parties and then refer the matter to the alternative dispute resolution mechanism. This is how the Supreme Court has laid down the guidelines for the judges to refer the matter to the court. Even it also pointed out how the meanings of the third and the fourth clause of Section 89 needed to be exchanged to rectify the drafting mistake. Even whenever I was discussing the Section 89, so I was clearly mentioning about the error, and the same error was rectified by the Supreme Court in this case, that it is required to be exchanged to rectify the drafting mistake. And it also held that obtaining consent of the parties for reference to arbitration was necessary under Section 89 of the Civil Procedure Code. And it also briefly touched upon the creation excluded categories of suits under the Section 89. So what types of cases that cannot be referred to the arbitration or conciliation or lok adalat or mediation is included under this act. So excluded categories of the cases are been dealt by Supreme Court in Afcons case, that is representative suits cannot be referred to alternative dispute resolution, any of the alternative dispute resolution, election, dispute relating to election to public offices, cases involving grant of authority by sections after inquiry, cases involving serious and specific allegation of fraud, fabrication of documents, forgery, impersonation or coercion. Such cases should not be referred to mediation, conciliation, arbitration or lok adalat. Cases requiring protection of sections, for example, claims against minors, deities, and mentally challenged and suits of declaration of title against the government. Such disputes should not be referred to the alternative dispute resolution mechanism, or cases involving prosecution of criminal offences should not also be referred to the alternative dispute resolution mechanism. So these are the categories of cases that are excluded to refer for the alternative dispute resolution mechanism. In this case, the Supreme Court has also laid down what types of cases can be referred for the ADR mechanism. The disputes relating to trade, commerce and contracts, strained relationship, continuation of pre-existing relationship, tortious liability including motor accident claims and consumer disputes can be referred to mediation, conciliation or arbitration or lok adalat. So other provisions of CPC such as Order 32A, Rule 3, where a duty is being imposed upon the courts to make efforts for settlement in suits relating to matters concerning of a family, and Order 37, Rule 5B, cast a duty upon the court in a suit against the government or a public officers to assist in arriving at a settlement. So these are the other two provisions which encourages the alternative dispute resolution in India. So there are various other legislations like Family Courts Act of 1984, the Companies Act of 2003, the Commercial Courts Act of 2015, the Consumer Protection Act of 2019, the Mediation Bill of 2021, the United Nations Guidelines on International Settlement Agreements resulting from mediation 2018, the well known as the Singapore Convention on Mediation. So these are the other legislations which encourages mediation in India. So basically, the growth of alternative dispute resolution has even boomed the mediation as well. And the mediation, when speaking out or comparing with the other legislations or the other alternative dispute resolution mechanisms, that is arbitration, conciliation and lok adalat. So mediation is one of the effective tool for resolution of a dispute. And in the upcoming week, we will be discussing on how mediation is different from the other alternative dispute resolution mechanism which is recognized under Section 89. And we are also discussing all these legislations which have encouraged the mediation in India. As this course is specific on a mediation chapter, so I have included the legislations which have specifically encouraged mediation as a course of settlement of a dispute and not concentrated more on the other alternative dispute resolution mechanisms. And the other alternative dispute resolution mechanism we have discussed in depth in the second week when we are comparing these alternative dispute resolution mechanism with mediation. So we have discussed over there. So that's why we have not touched upon here in depthly with the dispute or the legislations relating to the other dispute resolution mechanism. So with this, I conclude with this session. Thank you.